Hello, and welcome to the last week of the MConnects crash course on intellectual property. My name is Jennifer Judge Hensel, and I'm with the University of Michigan College of Engineering. I'm going to be your host today. I'm joined today by our two experts. We've got Bryce Pilz, who is a law professor at the University of Michigan working in the Entrepreneurship Clinic. Hi, Bryce.
Hi, Jennifer. Thanks for having me.
And our second expert today is Anna Heinel, who is an attorney from the law firm of Brooke Cushman. Hi, Anna. Thanks for being here.
Hi, I'm glad to be here. Thank you.
So we're here today to talk about intellectual property and specifically about forming your company. We're going to cover how to start off on the right foot by making sure your startup owns the intellectual property in its product or service. This crash course is brought to you by MConnects, which is an alumni engagement program with Michigan Engineering. You can find out more about the program, participate in a webcast, or maybe watch some lectures or videos on demand by going to www.engine.umich.edu/mconnects. Before we get started, I wanted to remind you guys that this is a Q&A format, so we encourage any and all questions at any point during the program. They can be about general intellectual property or specifically about your product or company. The more relevant it is for you, the better off this is going to be. If you're watching this on the MConnect website, you can just scroll down to the bottom of the page and enter your questions in the discussion field, but you can also tweet the questions to @MConnects, or you can put them into the Google Hangout or the YouTube page. We're going to be watching all four areas today. A quick disclaimer here. The information in this program is provided for informational and educational purposes and does not constitute legal advice. You should consult your own attorney with your specific legal questions. University employees should consult their Office of Technology Transfer concerning university inventions. The information provided in this program is general in nature and does not necessarily reflect the views or positions of any university, law firm, or client associated with any instructor or guest. So let's go ahead and get started. Bryce, why don't you start by summarizing this week's topic and maybe some key points from the videos.
Hi, everyone. Thanks for joining us. So as you recall, we've been talking about intellectual property issues for startups and people that are thinking of commercializing a product or service. In the first 2 weeks, we talked about the various ways that intellectual property can be used to give you a competitive advantage and how it can apply to aspects of your product or service to make it more difficult for competitors to compete against you. Last week, we flipped the script and talked about the intellectual property of others and whether you can actually deliver your product or service to your customers and not infringe upon the intellectual property rights of others. So this week, in the dramatic season finale, we assume that you've come up with a product or service and a viable business model that you think is scalable and repeatable, and that you think it makes sense to go forward. And now it's time to actually form a company. And what are the intellectual property issues that come up at the time of company formation? And generally, especially what we see here at the clinic, and what I'm sure Anna sees with her early stage clients, are difficulties in selecting a name for your company or a brand for your product that's both strong and sound in a trademark and a business sense and doesn't raise any unnecessary risks that you may be violating the rights of some third party. And then also, does the company actually own the intellectual property that it intends to use, and it intends to use it as a competitive advantage? And we often talk about that in terms of getting the intellectual property into the company and making sure that you had the right people sign the right documents and they actually have the right to transfer rights into the company. So, Anna, thanks for joining us. In one of the videos that the audience watched this week, we talked about the spectrum of distinctiveness for trademarks and how some marks that are arbitrary or fanciful, like Google or Apple maybe, are stronger in a trademark sense than more descriptive marks that actually describe the underlying product or service you're trying to sell. Can you talk about how an entrepreneur should think about picking a name for their company or product so that it's both strong in a trademark and in a business sense? What should they be thinking about?
Well, there is a spectrum of distinctiveness that goes from generic all the way through to fanciful, which would be a made-up word. And the closer you get to fanciful, the stronger and more distinctive your mark is going to be. For example, you can't choose a mark like Apple to describe an apple, or because that would be considered generic. But that same word, as we know, applied to a computer is not at all descriptive because there's nothing about a computer that has anything to do with an apple, so then it becomes arbitrary, which is closer on the line towards fanciful. So there's generic, which is the paper for paper, the word to describe the item. Then there's descriptive, which kind of describes an aspect of your product. And then we move to arbitrary, which more arbitrary marks, it gets more to the suggestive nature of these marks. It's not specifically describing anything. And then as we talked about before, when it's a word that doesn't have anything to do, it's an actual word that has nothing to do with the product, and you move to something that's arbitrarily applied and therefore more distinctive, closer to fanciful, which is a completely made-up word. So the closer you get to a totally made-up word, the better off you are. However, what we see coming in the door a lot is, especially in the culture of apps and Google, and companies want to stand out as easily searchable, so you type in a word in Google and you're the first thing that pops up because you have a descriptive type of name. That can be very attractive to our clients. They come in the door and they want that kind of a name, but we try to explain to them that although that's good at first, when you're first establishing yourself, it'll be harder down the line because you won't be able to protect that mark and keep other people from using it.
Thanks. Yeah, it seems often that you're balancing trademark concerns and the business concerns. Here at U of M with student startups, we often see that they're advised on the business side to pick something that tells investors or customers the nature of their business or service, whereas intellectual property counsel would probably say, hey, just make up a word that's going to give you the strongest trademark protection. So it seems that there may be a sweet spot in the suggestive area. And I think maybe Jaguar is a good example of a suggestive mark. It doesn't tell you what the underlying service is, but it maybe suggests the nature of it. And so we often see startups, especially as you mentioned in the app or software space, trying to find that suggestive mark. So it seems there's kind of an important line between suggestive and descriptive, where you cross that line and now maybe you don't have a strong trademark protection because you're telling people the nature of the underlying good or service. Do you have any thoughts on how to, think about that line between suggestive and descriptive? So, for example, an entrepreneur wants to pick a name that hints at the nature of the product or service. How do they know when they've gone too far and they're actually describing the product or service?
Well, it's a very hard line to draw, and generally we recommend to clients that a good way to do it is to maybe pick a couple. You can pick something relatively descriptive and change it a little bit. Maybe cut it in half and combine it with another word, or think about, for example, with the Jaguar example, you think about, okay, it's sleek, it's fast. Let's pick something sleek and fast, something that embodies the same descriptive terms, but is not necessarily descriptive. So that's Jaguar is a good example. You want to get away from describing a certain aspect of the product because that will lend itself to a descriptiveness.
And so for the clients that do go the descriptive route, maybe there's just compelling business reasons, as you mentioned, search engine optimization and the ability to be found quickly on the internet or the app store sometimes outweighs the purely trademark advice. Is there still a way to get trademark protection when you have a purely descriptive name? It seems that there are stores we know of out there, the Burger Kings and the Best Buys of the world or Toys R Us's, that have picked pretty descriptive names, yet I'm guessing they have trademark protection. Can you talk about how that works?
Yes, that is something called acquired distinctiveness. So when a trademark owner has used a descriptive mark for a long period of time to the point where the public now associates that term with that specific business and not just a descriptive element, at that point a trademark owner can apply for protection or can have protection based on secondary meaning. So at this point they've they've acquired the distinctiveness they didn't have in the first place. Now you got to be a little careful here, because if your mark is generic, which is, you know, paper for paper, book for book, then you will never be able to establish protection, because that is the only word used to describe that item. And if you take that away for your own personal use and you take it out of the public, then you're basically misappropriating something that anybody can use to describe this item, because it's the only word that we have. And so you want to get away from something that's so descriptive, because that potentially can never be protected.
So it sounds like if you have something that's suggestive, arbitrary, fanciful, you're going to be able to initially get some trademark protection, assuming that it's
Yes.
clear and you have the right to use it. If it's descriptive, it's probably not immediately protectable. But if you use it as a brand consistently over time, and people start to see it not as a description of the goods, but as an indication of this is coming from a particular provider, then you can get protection.
Mm-hmm.
All right, thanks. So we've been talking generally about getting trademark protection. Can we talk a little bit more about how someone gets trademark protection? In the past weeks, we talked about patents and the rigorous and somewhat costly examination process for that. We talked about copyrights and how, while there's a registration process, something you reduce to writing is automatically copyrightable. Is trademark like one or both of those, or how does one get rights?
Well, I would say trademark is a little closer to the patent system than the copyright system. There is a substantive examination period, but from beginning to end, it starts with an application. You apply to the USPTO for registration. In a few months, you'll get an answer back from the USPTO, from an examiner, stating if there are any issues with your application, any confusingly similar marks that are on the register, or that it's descriptive, or that there's an issue with the goods or services description. And in that case, you have 6 months to answer them back and fix your application or argue against the refusal. And then there's a second round of that potentially if they don't accept your argument. But once you get past the examiner, there's a publication period, and so that's very important. There's a 30-day period where your trademark is published for the world to see in the trademark manual. I mean the trademark.
Gazette.
The Gazette. Yes, thank you. I'm blanking. In the Gazette. You have 30 days. It's published. If nobody opposes or extends time, then if your mark is in use, it will register. But that's a key thing too. If your mark is not in use, it cannot pass to registration. So there must be use before the mark registers.
And am I right that there's also something called common law trademark rights, that if
That
you
is
use
true.
a brand, you can get rights without registering? And why would one go ahead and spend the time and money to get the registration? What extra benefits do you get?
That is true. By simply adopting and using a mark in commerce, which means across state lines, you obtain protection where you use the mark. So if you use the mark, you can actually obtain protection. You don't even have to cross state lines. If you use it just in Michigan, in a small area, you can obtain common law protection in that specific area. The benefits with registration, it's as if you used it in all 50 states, as opposed to just where you use it. And so it gives you that broader presumption that you have this registration, you have this right to use this term. Where if you just use it, your rights are limited to where you use it. So other benefits of filing a trademark registration would be you get to use the little circle R, which you cannot use if you just have trademark common law trademark rights. You can use the little TM symbol, whether or not your mark is registered or unregistered. So I'd recommend, if you are adopting a mark, go ahead and start using that little TM. At least it's like putting up a do not trespass sign. Obviously, it's not an electric fence, but it at least lets people know that you think of this as property.
So I just want to jump in here really quickly, and first of all, apologize to our audience. We were having some technical difficulties with the video screen back and forth, but I think we resolved that. I do want to remind you guys that if you have any questions at any point, you can go ahead and ask them by scrolling down to the bottom of the page and putting them in the MConnects website, tweeting them to @MConnects, or adding them to the Google Hangout or YouTube.
Thanks, Jennifer. So Anna, we've been talking a little bit about when to register and how you can get common law rights. Can we talk a little bit about timing? And what do you have to have done with a trademark before you can register and try to get the rights associated with registration? Do you need to be selling the good, using the brand? Can you just be planning to do it? I know there's a famous scene from The Social Network where Justin Timberlake turns and says, "Drop the," just go with Facebook. When someone has come up with that great brand name like that, can they register it, or does there need to be more going on, and how's that work?
Well, you can file an application for registration based on use or based on intent to use. And so if if you have this great idea but you haven't started using the mark yet, but you intend to use it, you can file an application with the Trademark Office based on intent to use. Again, like I mentioned before, you have to file a document with the USPTO stating that you are using the mark before you can get a registration, but you can file based on intent to use. You cannot get common law rights if you don't use the mark, because common law rights are just based on where you use the mark. So if you come up with a great idea, you don't do anything with it, you don't use it in connection with goods or services, you're not providing, offering any kind of service or any kind of product using the mark, you cannot obtain use-based rights because you're not using it, but you can reserve the right to use it with the USPTO.
And am I right that one of the benefits of filing that intent to use application rather than waiting until your actual use to register would be that you get the benefits of a registered trademark as of the date you file that intent to use?
Once the mark registers, right, your priority date dates back to the the filing date of the intent to use application. If it never registers, you don't get that benefit. But once it registers, yes, it's as if you began using it the day that you've filed the application. You get that priority date. Right.
Yeah, I think anyone who takes trademarks in law school, you have these cases of, someone that has a name for an ice cream shop in California, someone else with the same name for the same ice cream shop, basically in New York, and so the example here would be if the New York shop opens and you later start using and file your registration, you may get constructive nationwide rights, but you'd be subject to those pre-existing rights where they're using it. If you filed your intent to use beforehand, you could beat them. It's perfected. All right. So you mentioned use. It seems a question that comes up a lot to us is how does a domain name relate to this? How do social media handles relate to this? If someone registers the domain name, do they have trademark rights, and does that count as using a mark in commerce, or do they need to be doing more with it? How does that work?
Generally speaking, merely registering a domain name is not sufficient to show use. If you use that domain name in connection with offering a service, for example, that can constitute use, but just registering the domain name is not use. Same thing with, for example, a Twitter handle. Just by creating that Twitter handle, it does not give you any rights. Theoretically, you could provide, advice services in connection with your Twitter handle. But if you just think of a business idea and you're using the social media to advertise that that product, that's not sufficient to show use unless there's a way to link to purchase the item.
Right. Would it be fair to say that it's almost like a domain name or maybe a Twitter handle? It's almost like a sign.
Yes.
That you could build the sign for your company, but if it's just sitting there in your office, you're not using it to actually advertise a good service, it doesn't give you any rights. It's interesting how they're related, because on the flip side, it is relevant whether your domain name and maybe Twitter handle are available. And if they're not, you'd have to pay someone $100,000 to get it. Maybe you should pick a different name. But at the same point, merely having one doesn't give you the rights maybe you think it does. Let's talk a little bit about trademark rights. It seems that there's often confusion. People will hear that, oh, someone has trademarked a certain term, and then they think, oh, so now no one can use that word in any way. What rights do you actually get when you have trademark rights in your brand? Does it, give you the ability to stop other people from using that word? Does it merely stop competing products? How should we think about that?
Well, the test in trademark law is likelihood of confusion. So it's a little broader than, well, it would depend on how many coexisting marks there are out there similar to yours. If, for example, the mark Delta is used in connection with many different kinds of goods and services, and so if you obtain a registration for something, your protection would be very limited because the public is used to distinguishing between different uses of Delta, for example. However, if your mark is very fanciful, unique, your protection could be a little broader because if somebody else comes out with the exact same unique made-up word for a different type of product, it's more likely that the public might be confused. So that again goes to the distinctiveness of the mark as well. But generally speaking, if there's a chance that the public could be confused and think that these two products or services emanate from the same source, then you have an issue. So that your protection covers anything that would confuse the public into thinking that this other entity is related to you. I think that answers.
Yeah, no, that's great. And I think this is once someone understands this and the test for likelihood of customer confusion, it starts to set in a little bit more the benefits you get from a stronger, more distinctive mark.
Mm-hmm.
For example, it would probably be hard to try to sell any product or service and call it Coca-Cola or Google today, just because they are such strong marks. On the flip side, maybe something like Delta or something that's used for a number of different products or services, you could probably start a chair company and call it Delta, maybe.
Yeah.
And it kind of shows you the benefits of a more distinctive mark. Another thing that we often talk to entrepreneurs about is this likelihood of customer confusion test that Anna just went through. It has multiple factors, and I often say if you're at the point in time when you're picking a name for your company and you need to spend more than 5 minutes really going through those factors, thinking about it, it may be too close of a call because you're not really concerned about whether you'll win the court case. What you're trying to do is avoid being sued or getting the nasty letter. And so maybe if you're the early stage entrepreneur, it's better to err on the side of caution and just pick a different name. So let's talk about IP ownership. So especially on campuses like U of M now, and in any entrepreneurial hub like we have here in Southeast Michigan, there's a lot of promotion of startups and entrepreneurship. There's things like Startup Weekend and hackathons, events designed to bring people together and to engage in the creative process and collaborate to build something. Can you talk about any intellectual property ownership concerns that stem from these events where people are collaborating together, yet maybe at the end of the event, not everyone that was involved in creating this early technology is going to be going forward with the company? What are some concerns related to that?
Yes, actually, that comes up quite a bit. You want to make sure that you, prior to trying to reserve any rights or obtain any registration or registered rights, you want to make sure that you own the intellectual property. So if you worked on it with another person or another group, you want to make sure that you have assignment documents in place, assigning all copyrights, patents, intellectual property, trademarks, anything that you created. We call that usually a general IP assignment. You want to make sure that all of these ideas are assigned to you before you can proceed with any kind of protection. And that's a pretty standard assignment document. Another thing, a very good thing to do too, is a work for hire document, and that in certain circumstances, especially if you work for, if you have a company and you have people who work for you who are creating things for your company, you can execute a document so that anything that they create for your company is property of your company as opposed to being property of the individual who may have created it in normal course of business. So it's very important to, in writing, wrap up those rights. That's another thing too. These kinds of assignments generally need to be in writing to be enforceable.
Yeah, I think that's a great point, is that you know, while we're generalizing a bit, you know, people do see the law as requiring that IP can only be transferred in writing. And we see this a lot on campus where 4 people work together on a project. You know, 2 of them get great job offers and are going to go off and do something else, and the other 2 are going to continue with the project. And the 2 that are leaving the project that aren't going to be involved in the startup, you know, say all the right things. They say, hey, you go ahead, you own all the equity, you own the IP, you know, we don't have anything, want to have anything to do with this, don't worry about it. And that's not good enough, right? You need to go to them and get something in writing.
And that is the time when everybody's friends. This is what I tell people all the time. When everybody's friends and everybody gets along and everybody agrees who owns the rights, that's when you execute the document. Because if you wait until there's an issue, people don't want to sign these rights away anymore. So it's best to do it when everybody's friends. People say, oh, well, this is so formal. You know, we're all friends. It'll be fine. That's when you do it.
Right, and you can blame it on the lawyers. You can say, you know, hey, my lawyer's making me.
Always blame the lawyer.
I think the other point to make is, you know, even if you believe that this person is so good and genuine that they will never come back and cause problems, it's really more of an issue with investors. That if you get to the point where you're going to raise money, or maybe, you know, Google is going to buy you, their lawyers are going to come in and they're going to discover that this project originated from one of these collaborative activities, and they're going to say, please show me the written document from individuals C and D that are no longer part of this project, and you're going to need to show it to them. So, you know, entrepreneurs are willing to take risks, but this isn't so much whether or not these people are going to come back and cause problems. It's what investors will expect to see down the road. So I think that's a great thing.
Because they want to avoid those problems.
Yeah. So one common situation we see on campus a lot is with software development, because you've got lots of people that have the great idea, but maybe they don't know how to develop the software, write the code, and so they go find the computer science major to build the original app for them. And sometimes they're even paying them. And they have this concept of work for hire. They think, well, this person's doing work, I've hired them, I've paid them, therefore I own the IP. And am I right? You know, that's not work for hire. Work for hire is in employment context, and that's independent contracting, and you absolutely need a written agreement there.
Yes. Yes.
Yeah, we see that
all the
people
time.
are making a mistake today, unfortunately. Jennifer, how are we doing? Do we have questions from the audience?
We actually don't have any yet, and I was just about to chime in and remind everybody that you can ask them by going to the Google Hangout, putting them to YouTube, tweeting them to @mconnects, or pasting them right into the bottom of the document.
So Anna, maybe let's go back to talk about cost, because it seems like that's one of the first questions people ask is, okay, you know, so if I go to a trademark attorney to register the mark and help me in selecting a name, kind of what's the scale of the costs? For patents, we talked about how it can be pretty costly. It can be $10,000 to $30,000 to get an issued patent, and understanding that every situation's different and things come up, but, you know, kind of where does this fit in terms of how much this costs to get a trademark registered?
Well, what we generally, I don't think we didn't really talk about clearance searching, which is something I want to bring up later, but we generally recommend searching for availability before filing an application, because you can kind of figure out whether or not you're going to have any issues and determine whether or not you should file an application. But generally a trademark search, a full trademark search, will conducted by a trademark attorney will probably be about $1,000 to $1,500 if you get a full search using one of the search companies that perform these searches, looking over hundreds of databases, and the attorney reviews it and gives you a report letting you know about availability. To file a trademark application and pursue it all the way through to registration, we generally recommend budgeting about $2,000 to $3,000 for a one-class application, barring any kinds of serious complications with third parties. That's what we generally recommend budgeting.
Great. And so you brought up the concept of clearance, and that's a great thing to talk about. So we've been talking about how to affirmatively establish rights in your mark, and we talk about likelihood of customer confusion. You have this multi-factor, kind of sliding scale test. How do I know that the mark I've picked, whether or not it's a strong mark for me, doesn't infringe the rights of someone else's? Because it sounds like it's not just an issue of whether I have the identical name to them. It's the standard is likelihood of customer confusion.
Yes.
Can you walk us through the importance of that and how one goes about that analysis?
Yes, yes. We generally recommend performing a trademark search before using or filing an application for registration for a trademark. Because you never know if the name that you adopt somebody else is using unless you perform a search. Now you can do a little bit at home. If you first come up with the name, you can Google search it. That will only show you some use that's out there, won't show you everything. A lot of businesses, I know it's less and less common now, but some businesses don't have an internet presence, and they can still be a risk. At the same time, too, simply searching the USPTO database for registered marks, one, your search probably won't be broad enough to cover things like different vowels that may make the term sound the same. But also, it only shows you what's been filed, what's registered, not necessarily use that's out there. So really, the only you can do a pretty good job looking on the USPTO database, looking on Google to see if there's anything out there that's a clear, okay, we gotta look for something else. But to really clear a mark, you really should do a full search over all kinds of periodicals and databases that a search company can do for you, and an attorney can review, and based on the multi-factor likelihood of confusion test, give you a clear answer as to whether or not you'd be facing any risks with adopting that specific mark.
So I have a question from the audience that follows along this train of thought. Ben is wondering, he put this on the website, if he already has a logo and a name developed, should he trademark just the name or how it looks with the logo, or both? Does it make a difference?
Yes, it depends. You get the broadest protection from filing the name itself without any kind of limitation as to how it can be presented. If you file an application for a logo, although it does to a certain extent protect the name itself, to maintain that registration, you would have to keep using that same logo all the time. So your protection is going to be narrower. Sometimes we will recommend that a client file a logo as opposed to a word mark. Sometimes based on other things that are out there, it might be able to differentiate you enough from somebody else out there using something similar to give you an argument against confusion. But for the most part, the strongest thing you can do is to secure the word mark. Of course, you can file an application for the logo and for the word mark, and if you're using it for example, like an app or something where you have the little icon and the square, and that's going to be a key source identifier for you, then it would be important to protect that property. But if it's the same name, just in a logo format, you can file both, but the strongest position would be to file the word mark.
And I'm guessing that as a company grows and maybe they get a little bit more sophisticated in how they think about their overall brand protection, they may have multiple trademarks.
Oh, yes.
With a line,
and
one on the mark, one on the slogan.
And defensive registrations. Maybe trying to block people, out of certain areas using intent to use registrations. There are all kinds of things once a business grows to broaden your protection to keep third parties or infringers or counterfeiters from trying to pass themselves off as related to you.
So I want to go back to when you were discussing the clearance process. Am I right that the reason why someone cannot simply just search the USPTO database, the trademark database of registered trademarks, is going back to your earlier point that you can get rights through common law use or registration. So when I have a name and I want to try to clear it and make sure it's not infringing someone else's rights, if I just search the USPTO database, I'm only seeing those that are registered. There could be someone who used it, and I could also be infringing their rights.
Yes, that's true. And another thing, too, just because you can go on the USPTO database and you can see marks that have been abandoned or have been canceled, so they're no longer active registrations, those can still sometimes be a risk because the company may have, for whatever reason, they decide not to maintain their trademark rights, they could still be using it. So in trademarks, use is king. Use is a key component because you can't have a trademark without use, and so the use is the essential element that you're protecting here, your use in connection with this mark.
Do you have any advice for the process of a couple entrepreneurs trying to come up with their company name? We see this a lot at the entrepreneurship clinic where students come to us and they've just pulled an all-nighter where there was, that was their night to come up with the company name. And they brainstorm and they have a name and they love it because they think it's the most clever thing ever, and they've already pictured 5 years from now when they're going public under this name. And we'll help them with some of this early clearance analysis, and we'll find a name out there that causes enough concern where they really should switch their name. But because they've already fallen in love with their name, it's really hard to get them to switch their name. Is there a way that maybe they can incorporate the trademark analysis more into their name selection process, so it's a little bit easier to maybe before they fall in love know that it's a name that'll be there for a while?
Yes. What we usually recommend is that clients give us a list of names, a list of ideas, and then we can perform a smaller scale knockout search, we call them, where we do our own searching of state and federal trademark records and different internet, websites, search engines. We look at domain names, we look at social media, and try to see if there's anything out there that's a clear block. These searches we conduct for less, like typically no more than $200 to do a quick knockout search for each of these marks. And then we can come back and say, well, these 5 marks look like we can do further searching on them. And then we can choose and we can do a full search on one or all of them. And we can say these 5 marks, don't waste your money on a full search because it looks like they're blocked. And so that's a good way for businesses to choose a name that gives them some options to choose a name that's probably lower risk. It's very hard to tell somebody who's fallen in love with their mark that they can't use it. But it happens. It happens often.
Right.
So we have another question that came in from Google Hangout, and I just want to remind everybody that if you do have any questions specifically about your company or issues that you're facing or just in general, you can ask them at any time. Ben, it says that he has a co-founder of a startup that he's working on who also happens to be working for somebody else during the day. They're kind of moonlighting together on this project. And he's worried, should he worry about the current employer that this person is working for actually owning any of the startup later on or saying that they contributed to it because she was working for them?
Yeah, so common situation where, you have someone who has a job and perhaps it's that expertise that they've learned on the job that you're trying to tap into, or maybe just, they're still taking that salary, while they're helping you on the side, maybe trying to figure out whether this startup has enough potential for them to actually make the leap and leave their job and join that startup. Anna, I'm guessing you see this from time to time. Do you have any thoughts on cautions they should take?
Yeah, it goes back to the work for hire issue. You want to look at any agreements that the employer might have in place with the employee. Sometimes these employment agreements can be very broad and include everything, all intellectual property. Whether or not how enforceable these are is another question altogether. But sometimes the agreements with the employer can be very broad. So you want to make sure that the person that you're working with is very clear on what they own and what the employer claims to own. Another thing too is you want to avoid things that would make it seem like the individual is working in the normal course of their business. For example, don't have them writing your code, writing code for you when they're at work, because then you kind of blur the lines a little bit. Not using their work property, things like that. That can strengthen your argument that whatever you're doing was not in connection with work, it was separate and apart. So you want to separate your activities. That'll also give you a basis. But it's very key to know what the agreement, the employment agreement states.
Yeah, I think that's a great point. These employment agreements are probably much broader than you imagine. Often what you're most concerned about is the optics, because of one of the ways this comes up is when you go to raise money and the venture capitalist realizes, oh, this person was working for big company X early on while they were writing code for you, and that venture capitalist maybe isn't going to really dive into the law and the enforceability of that broad employment agreement, but they're going to be concerned about were you using any of the company resources, all the way down to the pens and pencils and computer and where you were when you were doing this, and just how closely does it relate to your responsibilities for that company. And so you really need to think about the optics and disassociating this work this person's doing for you as much as possible from the company. And I think if you can't, you're at the point where you either need to decide that this is probably not an ideal person to be working for you, at least until they're willing to make that leap, or this person needs to raise it with their company and get some sort of consent from them to be doing this on the side, because that will help you a lot. But understand that's also often hard to get from these big companies, because sometimes they're like, we don't know exactly what you're doing, and so we're not going to give it up yet. And I think it goes back to what we call chain of title, which is, again, you need to make sure the IP is getting into the startup, so you need to have anyone who's contributed to the technology signing something in writing, and make sure that those people actually have the rights to transfer. Because if their employer has the rights, it doesn't matter what document that person signs, the rights are already tied up with the employer.
So are there specific, you've mentioned having people who aren't interested in being part of the startup leaving, have them sign off the rights. Are there any other specific risks for people who venture together, maybe don't have necessarily close ties, and you want to make sure that you cover all of the bases from the very beginning, that these people are in it for the long haul and you're not going to have any issues later on?
Yeah, maybe I could just talk a little bit about the documents we typically use. One of the things that we see with startups, in particular tech startups, is that the documents that are used to set up a company have become very form-based. And that's not really because people are trying to cut corners. It's just because, again, a lot of this is investor-driven, and so venture capitalists are looking to see certain documents that look a certain way when they go to invest in a company. And on the intellectual property side, these documents are typically called either a PIA or CIA, that stands for Proprietary Information Invention Assignment Agreement, or Confidential Information Invention Assignment Agreement. And that covers, like what Anna described earlier, just making sure that anything that's created, resulting from this relationship between the startup and this person, is assigned to the company. And usually there's some confidentiality language there too, saying you're not going to go and disclose confidential information you've learned from the startup. So that document typically covers the relationship between the engineer and the company. And if you have a founder, someone who's been working on the technology before the company was formed, you probably also need just a blanket IP assignment that says there's existing IP that exists today, even prior to incorporation, and all of that needs to be assigned into the company. And then the example we gave of an existing employer or someone moonlighting, there needs to be a little bit of due diligence to find out, does this person have anything that kind of encumbers or gets in the way of this chain of title going into this company. Anna, do you see anything else?
Yeah, and another. I just wanted to speak to the that these documents are kind of form-based. That has a lot to do with a legal aspect too. That there are certain words that the intellectual property statutes require to be in these documents. You want the exact wording to be just right in these documents, or else your assignment might not be enforceable. Another thing too, especially with work for hire, we always recommend never just do a work for hire by itself. You tack an assignment on the back of it. So just in case you don't have that, there are very specific requirements for work for hire. And if if for whatever reason your work for hire falls through, you have the assignment underneath it to catch it. So it's because of the very specific wording and the very specific requirements that these documents tend to look similar.
Yeah, I think sometimes people tease us lawyers for using certain terms like hereby, but I think you probably tell people there's cases that distinguish between a contract that says hereby assigns interest and contracts that say you agree to assign. One of those, one that uses the nasty word hereby, actually works to transfer the IP in. The other one just says you'll transfer it later.
Yeah, you agree to. And it depends on the whole document too. I mean, because you have to read the document together, and sometimes courts will forgive things like that if it's clear from the document the intention of the parties. But at the same time, wording is very important in these documents.
Right.
So we have another question that's come in from the website, and I just want to let everyone know we're wrapping up soon, so if you do have any more questions, to please jump on and ask them now. Sarah says that one of her co-founder has been talking to other people about the idea and what he's been working on, and she's wondering if she should be worried. They don't have a patent yet, and she's wondering if they should get these documents that you're talking about created now in order to prevent any problems.
I'm not a patent attorney. Without more information about the situation, it's hard to tell. Obviously, if you have a great idea, it's probably pretty good to get it under your hat. Keep it under your hat until you have your rights locked up. So if you get a chatty partner, now is the time to start securing those rights. Bryce, do you have anything to add?
Yeah, we get this question a lot. I think, as Anna's saying, it kind of depends upon the specifics and what this person is sharing. And my overarching point is, she needs to have a conversation with this co-founder, and they just need to get on board and understand what types of information do they need to keep to themselves right now because they think it's proprietary, and maybe they want to pursue a patent, and therefore they don't want to be publicly disclosing it because, as we learned in week 1, that can hurt your patent rights. Or it's just sensitive enough that they kind of want to keep it internal now and maybe use it as a trade secret. And then what is broader information that they're willing to share? Because there's a lot of teaching now suggesting that these entrepreneurs should go out and talk to as many potential customers or partners as possible and actually validate whether people will actually buy this product or service before you invest all this time in creating this company. And so, I think there's a trade-off here, and that generally speaking, that customer discovery and talking to people about what problems they have, what pains they have, and how they'd like to see it solved, you normally don't need to disclose very much of your ideas, because mostly what you're doing is just seeing whether they have a problem and what it would take to solve it, and you don't need to be selling them on how great your idea is. So if you're doing customer discovery right, you don't even need to really get into your secret sauce. But to the extent you do, there is a lot of benefit from testing and seeing whether the people are actually willing to pay for this thing that you're seeking to invest in. But you do need to be smart and know that if it's something that may be patentable, talk to a patent attorney first, or if it's something where you really think someone else could act on it and you'd be losing some of your competitive advantage, then you just need to get on the same page and understand what level of discussion are we willing to have in a public nature, and what do we need to keep amongst ourselves because it's proprietary and there's some strategic value to keeping it close.
And back to the trademarks too, if you have a fantastic idea for a name of your business, you haven't started using it yet, be careful, because somebody might come along and steal your great name and start using it before you, and then it doesn't matter who came up with the name, it matters who started using it first.
Right. Yeah, this comes up a lot with investors, where people go out and start talking to early investors, and the general rule is that most investors will not sign non-disclosure agreements. So there does need to be this decision as to at what level of discussion are you going to talk to these people. Now, generally, investors work on reputation. They work in a close-knit community, and the last thing an investor is going to do is actually go and try to take someone's information and use it against them. That's just not how they work. But often too at these early stages, you're not talking at that level of specificity where you need to get into your secrets. You're usually talking about the problem, the market, who your team is, and how big this would be if it actually works. And then maybe as discussions progress, either there can be some sort of NDA or you're comfortable enough with this person where you can talk about more of the specifics.
All right, great. Is there anything else that you guys wanted to add, last minute things before we wrap up today?
Anna, anything else? I think we've covered a lot.
I think we've covered a lot,
Great. Well, I want to thank you guys for being here today. We're going to go ahead and wrap up. We hope you guys all enjoyed our discussion this week. This is the final week of our crash course, so although we are done with the live events, we want to remind everyone that you can go back and watch any of these on demand or continue to ask your questions on the website. I'm sure Bryce will be popping in at least from time to double check and make sure we're all settled there. Thank you, everybody, for participating. Thank you both for being here today. Thanks, Anna. It was nice to meet you.
Nice to meet you.
And thank you, Bryce, as usual.
Thanks, everyone. Thanks, Anna.
All right, and thank you all for watching. Have a great day.